Hello, welcome to Protecting the Rights of Renters in Foreclosure. I am Aileen Flanagan and I am a staff attorney with Lawyers Committee for Better Housing. Mark Swartz, the LCBH Legal Director, started the Tenants in Foreclosure Intervention Project in 2008, and since then LCBH has been on the forefront of the foreclosure crisis and how it is affecting tenants. LCBH is reaching out to all of our partners in Illinois to offer support to you and your work on the ground within your communities. Because we have been addressing the foreclosure crisis since 2008, when it started to affect tenants in Chicago, we have developed a specialized knowledge of the legal issues facing these tenants. Please feel free to contact us if you have questions about any of the materials this webinar covers. LCBH is committed to supporting your efforts in protecting the rights of tenants. For this cover picture, I invite you to imagine the housing stock where your clients live and work. I know it looks like Chicago, but foreclosure is affecting everyone in Illinois. Lawyers Committee for Better Housing serves low and moderate income tenants, and its mission is to increase and preserve affordable housing. We represent tenants in Chicago, counsel tenants across Cook County, and now, through the generous funding of the Illinois Attorney General's Mortgage Settlement Grant, we are able to reach out and help tenants throughout the state of Illinois. This webinar provides an overview of the foreclosure timeline and the federal and state laws protecting tenants in foreclosure. I invite you to contact us at LCBH because we would like to learn what problems you are confronting when your clients are caught between the landlords, the banks, the real estate management companies, and last but not least, the condo associations. We have outlined the problem in our reports for 2009, 2010, and 2011. And in June of 2013, we published our latest report entitled, Housing Instability for Renters Continues. Chicago Responds with Adoption of New Tenant Protections. You are welcome to take a look at these reports at our website at lcbh.org. Some of the problems tenants confront are multiple parties claiming ownership of their buildings, owners who stop maintaining buildings, successors in interest who refuse to acknowledge tenancies, make repairs, or maintain utilities. And many tenants lack legal representation. There is a general misunderstanding of the rights and responsibilities of both tenants and owners provide false and threatening notices designed to scare tenants. Many owners post coercive cash for keys deals. LCBH's findings about due process and other violations of tenants' rights in Chicago has been observed in jurisdictions across the country. It is exacerbated by the length of time a foreclosure takes in Illinois. These are some notices we have seen, and they are often either complete lies, half-truths, or they out and out threaten tenants. They are illegal because they are designed to intimidate tenants and get them to leave the building before the tenants are made aware of their rights. None of these are valid, but they should be taken seriously because often they are done by people who think they have the right to do these things. These notices set the tenant up for a follow-up contact by the real estate agent, who then offers cash for keys. This is where they offer to purchase the rights of the tenant to remain on the property for a period of time. Tenants who know their rights will probably recognize that the cash for keys is less beneficial than their rights under the law. Many of these notices are not even honored by the agent. They are really intended to coerce tenants into moving out. Sometimes these offers are nothing more than fishing expeditions designed to learn the identity of tenants so they can then serve a 90-day notice. Or in other cases, the offer will entice the tenants to try to be out. However, there will be so many strings attached that although the tenant gets out, they rarely are paid the money. What can we do about these unfair practices? LCBH established the Tenants in Foreclosure Intervention Project in the fall of 2008, and we established relationships with community-based organizations, training them on the law and providing an early warning system. Since then, we have developed some strategies designed to assist tenants and communities. Counseling is a service we provide for tenants who call the hotline or go into our information desk at the Daly Center Courthouse in Cook County. We look up their property using public records or proprietary databases, advise the tenant of the status of their building and the status of the foreclosure case, what is likely to happen in that case, and what their rights are. We can also provide referrals to your organization or the regionally appropriate legal service organization for tenants. This is the LCBH Statewide Tenants' Rights Brochure. It is available on our website. It provides a very nice synopsis of tenants' rights in the back left panel of the foldout, and in this legal training we will provide the statutory and legal authority for these rights. As you can see, there is a section intentionally left blank in the center panel, and we can work with you and your organization to insert your contact information there. We have also recently published a Spanish version of this brochure. In addition, as amendments to the mortgage foreclosure law related to tenants is expected to be signed into law by the governor, LCBH will continue to update its brochures and other legal material. You are welcome to view and download these brochures on our website at lcbh.org. As you know, foreclosure can be a year-long process and can be confusing to tenants. The tenant is not a necessary party and is usually not named. They rarely hear about the foreclosure. The judgment of foreclosure happens in the middle of the case, is not a final order, and the owner still has time to redeem the property. The court sets a sale date, and even after the sale of the property, the owner is still on title because the judicial sale deed is only an irrevocable offer to purchase the property until the court confirms the sale. As a result, this is a dangerous time for tenants. As the foreclosure process moves forward, the owner's incentive to manage the property declines, and this can incite tenants to withhold rent. This will jeopardize their ability to rely on tenant protection laws. The foreclosure process itself is also confusing, and often no one knows who has the right to demand rent and when. Often tenants make fatal mistakes, thinking the landlord is not entitled to rent, and that will cost them all the protections available for tenants in foreclosure. Tenants' rights flow from three different sources: federal law, state law, and local or municipal ordinances. Local building codes may apply to the property, and it stands to reason that the successor in interest would be held to the same standards of maintaining their property as any other building owner in the municipality. Tenants' rights are only as strong as the local municipality's interest in enforcing its building codes and local ordinances. We will first address the federal law protecting tenants at foreclosure. Aptly cited as the Protecting Tenants at Foreclosure Act of 2009. First enacted in 2009, it was part of the Helping Families Save Their Homes Act. After problems began to arise, demonstrating a need for clarity, the act was clarified and amended by Section 1484 of the Dodd-Frank Wall Street Reform Act. The language you see in red is what was clarified. It is important to see what has been stricken to give clearer meaning to what was maintained. The original act said an immediate successor in interest takes the property subject to the rights of any bona fide tenant, as of the date of such notice of foreclosure. This language was being misinterpreted and giving tenants very little protection. In Illinois, the notice of the date of foreclosure is in fact the date of the filing of a lis pendens, which meant that if a tenant entered into a lease at any time throughout the pendency of the foreclosure suit, the PTFA would not apply. This would not provide much protection to the tenant, and this did not make sense in some jurisdictions, so Congress clarified it. You should also be aware that some bank attorneys are using the older version of the Act, and it is helpful to have the clarified version with you. It is important to note that the clarification refers back to when the Act was first enacted. In addition, the sunset on the original Act in December of 2012 was extended to December of 2014. As you may be aware, there are current efforts to adopt the PTFA as a permanent addition to Illinois law, and the governor is expected to sign these amendments into law to take effect in the fall of 2013. The PTFA maintains the tenancy after foreclosure and protects bona fide leases and tenants. In addition to preserving bona fide leases, the PTFA requires the bank or subsequent purchaser referred to as the immediate successor in interest, or SII, to provide 90 days notice indicating they have 90 days to vacate. This notice must comport with state law. Further, the successor in interest must be on title before they serve the 90-day. However, it is also important to remember, even if the tenant qualifies under the PTFA, he can still be evicted for cause. The Act extends to leases which are greater than the 90-day notice period, unless the successor in interest intends to reside in the property. The Act seems to cover all dwellings and is fairly expansive in its reach. The successor in interest will generally not attack whether the property itself is covered, because if it is a dwelling, it's covered. The attack will most likely be on the status of the tenant or the lease, and in particular whether the rent is substantially below market value. Who is a bona fide leaseholder or tenant? The successor in interest will ordinarily challenge the status of a tenant and try to defeat his rights under the PTFA by proving the tenant or lease is not bona fide. The successor in interest in Illinois has a statutory duty to inquire into the status of the property. We believe they are an inquiry notice about leases and tenancies. The PTFA does not say anything about a burden of proof. However, given the legislative intent of the Act to protect tenants in foreclosure, it is fair to conclude that once the successor in interest initiates this inquiry and asks the occupant for information, we believe the tenant has the burden to answer or produce their lease, indicating that he is a bona fide tenant with a bona fide lease that extends beyond 90 days. Once the tenant asserts his status, we believe it is arguable that the burden of proof that he is not a bona fide tenant shifts to the successor in interest to challenge or disprove bona fide status. We find the banks often try to shift this burden onto tenants to prove they are bona fide. Finally, it seems the tenant must have paid some rent to the mortgagor in order to qualify the lease as bona fide. A Georgia court held that 30% below the market value rent, as testified to by plaintiff's expert witness, is substantially below market value rent, and therefore found the lease was not bona fide. Harper versus J.P. Morgan Chase Bank. This is probably one way we will see the plaintiffs attack bona fide leases. Where the tenant has a subsidy, the PTFA seems to require the successor in interest acknowledge not just the term of the lease, but also the lease itself. This may provide greater protection to a tenant receiving a subsidy, because the HAP contract remains intact. Now that we have explored the PTFA definition of a bona fide tenant, I would like to pose this question. A bona fide lease includes any of the following so long as they are entered into prior to the confirmation of sale. A lease that the landlord or owner entered into with the landlord or owner's sister. B, a lease that was oral and not written. C, a lease where a Section 8 housing choice voucher paid for 80% of the rent. D, a lease that extends for 3 years. E, all of the above are correct. The answer is E, all of the above. A is because a sister is not one of the immediate family members who is excluded from protection. B is because an oral lease is not excluded from protection, it will just be harder to prove up. C is because the requirement that the rent be paid market rate is calculated to include the subsidy. And D is because there is not a time limit for a lease term to be valid. It should be recognized that an unusually long lease term could look like it's not bona fide, but we have seen tenants who are induced by a landlord who is about to lose the property to execute a lease for a long term and require large sums be paid by an innocent tenant up front, well past the owner's ownership interest and right to demand rent. The lease looks suspicious, but it's really the conduct of the prior owner that is wrong and not the tenants. Now let's turn our attention to state law, which also provides protections to tenants residing in foreclosed property through the Illinois mortgage foreclosure law, and also when a tenant is being evicted through the Illinois Forcible Entry and Detainer Act. I would like to direct your attention to the IMFL amendments attached to this website. They are directed to expand protections afforded to tenants in foreclosure. The Illinois mortgage foreclosure law provides protections to tenants in several ways. It requires certain notices be provided to tenants by the successor in interest and also receivers. It also protects tenants being evicted within the foreclosure case in supplemental possession petitions. The Forcible Entry and Detainer Act also affords rights to tenants being evicted, and the PTFA is enforced here. There may be other municipalities in Illinois with additional protections. This presentation, however, is focused on Illinois state law. The Illinois mortgage foreclosure law provides the lease is not automatically extinguished in foreclosure, and nothing in the IMFL is specific about how to terminate the lease. The Illinois mortgage foreclosure law requires that a change in management notice be provided to each occupant of a foreclosed property. A receiver or a purchaser of the foreclosed property must, within 21 days of the confirmation of sale or appointment of receiver, make a good faith effort to ascertain the identities of the occupants and serve a change in management notice to the occupants, advising them that control of the property has changed hands, and provide information as to whom to contact for repairs. It is important to note what the law does not say here. Nowhere does it tell a successor in interest or a receiver how to demand rent. This demonstrates the public policy interest in elevating the management of the building well above the right to demand rent. If this notice is not provided to tenants, the successor in interest or receiver cannot collect rent. The tenant is protected from paying rent to the wrong party and is not required to pay twice. And a tenant cannot be evicted for non-payment of rent if this notice has not been served. Section 1508.5A2 is available on our website, but we should review it here because there are a number of problems. What happens when the successor in interest does not provide the notice within 21 days? Well, it sounds like they can't collect rent, but they do get another bite at the due diligence apple, because then it says if they haven't determined the identity of the occupant and his address, which is rather confusing. How could a successor in interest not know the address of his own property within 21 days? Then any time they do identify the identity of the occupant, they must provide the notice within 7 days thereafter. So there is another deadline, but that might be a tough road to prove at what point the successor in interest actually knew the identity of the occupant. Another problem is the payment of rent to another entity. It seems that the occupant is only protected from duplicate demands for payment if he paid another entity who had authority to collect rent at the time the occupant made the payment. This would likely be a court-appointed receiver, but not the former owner, who, as we know, is the most likely entity to demand rent from a tenant after confirmation of sale. But the tenant is not protected from this kind of fraud, even if the successor in interest is deficient in their diligence requirement, leaving the tenant vulnerable to this type of fraudulent conduct for long periods of time. This needs to be litigated and probably appealed. We believe the intent of this law is to protect tenants from the disruption of their tenancy due to the foreclosure process, and leaving tenants to bear the cost of double rent collection should not be the result. Let's take a moment to review the rights of owners, successors in interest, and receivers, and answer another question. When does a landlord-owner lose the right to collect rent from a tenant? A. When the receiver is appointed to manage the building. B. At the judgment of foreclosure. C. At the judicial sale. D. At the order of possession and order confirming sale. Or E. Both A and D are correct. The answer is E, because both A and D are points in the process when a landlord loses the right to collect rent. A. When a receiver is appointed, the court has terminated the landlord's right to collect rent. However, the receiver cannot collect rent until they have provided the change in management notice. It's not B, because the judgment of foreclosure happens in the middle of a foreclosure lawsuit, and the landlord maintains all the rights and responsibilities of ownership. It is not C, because the judicial sale does not pass title to the purchaser and the owner remains on title. D, the order confirming or approving the sale, an order of possession, is when the title is transferred and the prior owner, landlord, finally loses all interest in the property. When a receiver or the successor in interest wants to terminate a tenancy, they must follow one of two different paths, either by way of a supplemental petition or a forcible entry and detainer action. Receivers have specific authority granted to them by IMFL 1704 and can only be expanded by court order. It may not be within their authority to hire an attorney, in which case they may not be authorized to evict a tenant in a building they have been authorized to manage. It is important to see the court order appointing the receiver. Here you can see the Forcible Entry and Detainer Act and the supplemental process to evict require different procedures. The supplemental petition is a less desirable path for banks to remove tenants from newly acquired buildings because they must name all the occupants in the petition. The Illinois Forcible Entry and Detainer Act allows for the eviction of unknown occupants, and this is why most evictions of tenants in foreclosed property happens in eviction court rather than in chancery. The Illinois mortgage foreclosure law requires that a 90-day notice be provided to tenants prior to filing an eviction action in the Forcible Entry and Detainer Court if the successor in interest does not file a supplemental petition in the foreclosure case. Illinois law parallels the PTFA 90-day notice requirement. When a case is filed in forcible, all statutory requirements of Forcible Entry and Detainer Act must be met. In addition, all PTFA requirements must be met, and all PTFA enforceable defenses apply. Unfortunately, we see notices to the former owner and unknowns without noticing the actual tenants. Plaintiffs avoid naming tenants, serve the owner who has already moved. The sheriff's return of service notes this is why no service was made, and then they go straight to publication without ever serving the actual tenant. The successor in interest must meet certain obligations, and one is that they must do a diligent inquiry into the property within 21 days of the confirmation of sale. The successor in interest is going to have to manage the building for at least 90 days and should know the property and should not provide notices only to the mortgagor who they know no longer resides in the property. This is an abusive process, and they are doing it as a shortcut because they have not done the due diligence required within the first 21 days. How the 90-day notice must be served is an area of contention. Service of the termination notice under IMFL refers us to the Forcible Entry and Detainer Act for guidance. Some courts in Cook County follow Figueroa, requiring that service be made in strict compliance with the Act and does not allow for posting. But some judges in Cook County adhere to earlier case law, namely Prairie Management, which takes the position that posting of the termination notice is within the statutory permissive language and is an acceptable method of serving notice. If the plaintiff is a successor in interest, we look at these issues for possible defenses. It is our position that the 90-day notice cannot be addressed to unknown occupants. The notice, in order to be a notice, must be a notice to someone. The plaintiff cannot have filed prematurely, so look at the date of filing. Was the plaintiff on title on that date? In addition, PTFA defenses apply here, and if the tenant has a bona fide lease, this can be raised as an affirmative defense. If the plaintiff is a receiver, we look at these issues for possible defenses. Receivers have no authority unless and until they have been appointed by order of court. Look in the foreclosure case file for the order. Many orders appointing receivers restrict the authority of the receiver to hire outside counsel, so look at the order, because the receiver may be acting outside of his or her authority by filing the eviction lawsuit. Finally, in order to collect rent at all, the receiver must have provided the 1704F notice of change in management. No notice means no eviction for failure to pay rent. This is a quick checklist. Most importantly, when a receiver is evicting, check authority and look for the 1704 F5 notice. When a successor in interest is evicting, check the date of confirmation of sale against the date the 90-day was served. Tenants can be in and out of buildings during the foreclosure process, and it is much harder to name all occupants in a supplemental petition, so most successors in interest elect to evict in forcible entry and detainer court. In forcible court, the successor in interest can evict unknown occupants, and they cannot do that in the supplemental, so supplemental petitions are rarely used. The banks just don't know who is in the building. In addition, in many cases, the supplemental will be preempted by the PTFA if it is filed after the confirmation of sale. There is a danger to tenants if they are named in the supplemental petition or in the foreclosure case because the PTFA protections do not apply, nor do the IMFL protections. The PTFA only kicks in after the confirmation of sale, and supplementals are done during the foreclosure or 90 days thereafter. However, because it might be used, and because many people familiar with the IMFL, Section 1701, believe that the supplemental process is the way to evict a tenant in a foreclosed property, it is best for us to be able to distinguish when it is appropriate and what is required when it is being used. Therefore, although rarely used, we will look at the supplemental process in this and the next slide. If the tenant has paid rent or tried to pay rent, they get 120 days after service of the supplemental petition or the duration of the lease, whichever is shorter. And the order must allow the occupant to retain possession for 30 days after the order is entered. A mortgagee in possession, a receiver, a holder of certificate of sale or deed, or a purchaser at the judicial sale, asserting a failure to pay rent, must file an affidavit that the occupant is not current in rent. A tenant must also have been given the change in management notice and information as to whom and where rent is to be paid. We don't see many supplementals, and when we do, the plaintiff does not attach this affidavit to the complaint. So watch for this if you have a client named in a supplemental petition. This is the last review question. Please consider when a new owner or successor landlord of a foreclosed unit can file an eviction action against an occupant. A. 90 days after the new owner takes title. B. When the tenant does not pay the new owner rent. C. When the new owner demands rent and the tenant does not pay the new owner. D. When the new owner demands rent and the tenant does not pay the new owner within 5 days after being served a 5-day notice demanding rent. Or E. When the new owner provides notice of a change in management under the IMFL 1508.5 and then demands rent, and the tenant does not pay the new owner within 5 days after being served a 5-day notice demanding rent. As you all know at this point, a new owner or successor in interest cannot file an eviction action against an occupant until they have either served the occupant with a proper 90-day notice or have provided the occupant with the change of management notice, a demand for rent including notice as to whom to pay and where to tender payment, and finally a 5-day notice giving the occupant 5 days to tender payment, notifying the tenant that a failure to pay will result in a termination of tenancy. So the answer must be E. A could have worked if they had provided the 90-day notice first. Sealing of the record. This is a matter of right. Always make sure the order to seal language is in any order for possession if the property is in foreclosure. In Cook County, it took a while for the clerk to properly execute the order to seal. The order for possession gets out into the public domain in a number of ways, through third parties such as Lexis, and the clerk now reports to these third parties when a record has been suppressed. So you might have to monitor the process and work with your county clerk to ensure there is a clear procedure in place. We can collaborate with you to make sure this is being done properly. Here are some sample notices. This notice is a change in management notice, and its purpose is to advise tenants that the property has changed ownership or management, and provide a number for contact about conditions, and inform tenants that it is not a notice to vacate. The notice also contains the case number of the foreclosure. We have seen these notices, and we believe that some comply with the notice requirements and are fairly effective in providing tenants with the information they are statutorily required to provide. This notice is required prior to making any demand for rent. The problem with notices is that they stem from two legal authorities, and it can be confusing to try to comply with both statutes. However, the fundamental purpose is to provide notice that the tenant has 90 days before an eviction can be brought against them, and if they have a lease, it will override the 90-day time limit. In this case, the 1508.5 Notice of Change of Management fails to meet the statutory requirements in that it is not addressed to a known occupant, and it does not state all of the required notice language. It omits the statement that you may wish to contact a lawyer or your local legal aid or housing counseling agency to discuss any rights that you may have. This seems to be the first page of a two-page document. This page claims to be a notice of termination of tenancy, intent to file forcible entry and detainer action, and demand for possession. It is a menacing-sounding 90-day notice of intent to file an eviction. This notice is somewhat deceptive because it looks like the tenant is already in trouble and they are going to be evicted. The right not to be evicted for 90 days is buried in the last paragraph, and even worse, the right to have the lease recognized is further buried in the second page. So although there is nothing fatally wrong with this notice, we would like to see a better, less confusing statement of tenants' rights after a foreclosure. This notice is a condition precedent to filing an eviction action and must state that the tenant may remain on the property for 90 days. The statute does not direct any mandatory language, but this notice clearly states that they are terminating the tenancy in 90 days. The notice contains fair debt collection language at the top because the law firm providing the notice must be a collection firm, and this paragraph is included in all correspondence as a part of standard procedure. However, it is confusing to tenants who may already be concerned about paying rent, and they may conclude that they are in trouble if the landlord has disappeared and no one has collected rent for a while. This appears to be the second page of the notice. It seems to be an entirely different notice to occupants, and at the bottom it states that its right to demand possession is subject to your lease. Then the notice invites tenants to please send their lease and kindly include their name and number. It seems less threatening, but often people don't read the second page. That concludes our presentation. Thank you for your participation and attention. We would like to know what LCBH can do to support the work that you do on the ground. What do you need? We would like to provide brochures, provide counseling for tenants throughout Illinois, including your clients, host monthly calls where we as practitioners can discuss problems we confront or issues we are having, provide pro se form documents on our website and a shared database of pleadings, provide trainings and webinars to continue to expand your knowledge of this ever-changing area of the law. We are also interested in collecting your data on patterns of abuse of process or illegal and fraudulent behavior. Please contact me directly with any questions or concerns. This is a work in progress, and we will be improving and upgrading constantly, and with your help, we will provide valuable resources for tenants in the state of Illinois.